Texas Penal Code 3803, resisting arrest. Person commits the offense if he intentionally prevents or obstructs a person he knows is a peace officer from effecting an arrest, search, or transportation of the actor or another by using force against the peace officer. It is no defense to prosecution under this section that the arrest or search was unlawful. It is no defense to prosecution under this section if the arrest or search was unlawful. There's this video by Padilla, Mexican Padilla. He asks the police officers if he has the right to resist an unlawful arrest. They tell him no. That is the state of law. Texas does not allow you to resist even an unlawful arrest. Michael Laughlin then says Supreme Court says otherwise. Supreme Court, anytime anybody says Supreme Court says otherwise or says something, you can be pretty sure that they're lying. If they knew what they're talking about, they'd provide a citation. Supreme Court does not say otherwise. He says everyone has the right to resist an unlawful detainment or arrest up to the point of using deadly force. That is false. You do not have the right. We just read the statute. You don't have the right to resist unlawful detainment or arrest up to the point of using deadly force. There is no such right. Bill Brennan says, how? That makes no sense. The SCOTUS, I don't think, would agree with that. Well, what you think the SCOTUS would agree with is immaterial. The SCOTUS will deal with, in order to get to the SCOTUS, there has to be some sort of a constitutional issue at play, or a federal law that somehow supersedes the Texas statute. In order for there to be a federal law that supersedes the Texas statute, it would have to be a constitutionally authorized law. And as far as I'm aware, there is no constitutional authorization for penal codes that would reach Texas and their resisting arrest statutes. So the only other way it could be would be a violation of some other section of the Constitution. And what that violation would be, I don't know, and you don't either. So we don't know how the SCOTUS would be hearing it or what they would be ruling on, because literally it would have to be like some sort of a due process violation or some sort of a property right or something. I don't know what it would have to be to get in front of the Supreme Court, but it would literally have to be some sort of a constitutional question, and there is none that I'm aware of. So unless you know of what that constitutional question would be, then you're just farting in the wind. It doesn't mean anything. If it's done unlawfully and it's intentional, you can defend yourself. That is legal advice, and that is wrong legal advice. We just read it. In another context, if a rogue cop started shooting at me for absolutely no reason, I have every right to defend myself with deadly force. Well, we went from talking about resisting arrest now to a rogue cop shooting at you for absolutely no reason. What is absolutely no reason? Are you resisting arrest at that point? I don't think so. Yeah, if a rogue anybody starts shooting randomly for absolutely no reason, then yeah, you can defend yourself, probably with deadly force, if deadly force is warranted. So yeah, I mean, that's a stupid statement to make. It has nothing to do with resisting arrest, but thank you for making it. I appreciate it. So I said, don't give bad advice. There's no right to resist even unlawful arrest in Texas. Texas Penal Code 3803. It's no defense to prosecution under the section that the arrest or search was unlawful. Justice Liberty edited this, so he actually intended to say this. Good Lord. This should tell you how to feel about his advice. He says you both need to read John Bad Elk v. U.S. and then apologize to Michael Laughlin, Owen Plummer v. State, which was later upheld in the aforementioned case. Plummer v. State is a Supreme Court case. Oh, it's a Supreme Court of Indiana case. Who cares what the Supreme Court of Indiana says? They don't have anything to say about Texas law, and it is a meme, and it's misquoted. Blah blah blah. It's a misquote that says citizens may resist unlawful arrest at the point of taking an arresting officer's life if necessary. That does not appear in the actual case, but even if it did, it wouldn't matter because it is an Indiana Supreme Court case. John Bad Elk is a Supreme Court case. The U.S. Supreme Court got a hold of this case because it happened in Indian Territory in the Dakotas. So they were dealing with common law. This is prior to 25 CFR putting in criminal offenses, actual um, statutory criminal offenses into the Indian territories. So this is dealing with common law. Common law is no longer applicable. There is now statutory law. They held that the common law and the state of South Dakota and no statute of the United States, the state of South Dakota, or any common law gives the right to arrest, blah, blah, blah. So at common law, yes, there was a right to defend yourself against unlawful arrest, but that's gone away because there's no common law anymore. And you could see that in the Wikipedia article, superseded by statute. It's now there is a Code of Federal Regulations that tells you what is or isn't legal. And again, they go down to the internet meme and myth. It is not good law. So, Mr. Justice Liberty, you are a fraud, sir. The state of Texas has no authority to supersede this decision. Again, you're right. It doesn't have any authority to supersede Plummer v. State, which is an Indiana case. Texas has no way to supersede Indiana state law any more than Indiana can supersede Texas state law. And then John Bad Elk was specifically common law. It was specifically for Indian Territory, which constitutionally the federal courts and the Congress has a right to regulate. So it has absolutely nothing to do with Texas. But thanks for misleading 5 people there, Mr. Justice Liberty. Patty Casey says, search Sagon Penn. He killed a cop and wounded another and walked free. Yeah, that was in California. Once again, California law has nothing to do with Texas law. So, yeah. And Woodfield points out that's not unlawful if there's a record of outstanding arrest. It's probably true. Mike's Vids has, again, nothing. He never has anything relevant to add, so good job. Active Pooter, he points out Ford v. State, a 1976 Texas Criminal Court of Appeals case that dealt with 3803. Specifically, it's no defense prosecution under this section that the arrest or search was unlawful. And yeah, they upheld it. He says, which is strange because I was taught in law school otherwise. Well, in law school, if you were taught the model penal code, which is what Texas's law is based on, then you would know that model penal code took out the right to resist unlawful defense. Common law, which is the other portion of the penal code that you're, or not the penal code, criminal law. It's the part of criminal law you were taught in law school. In law school, they teach you criminal law and the model penal code. The criminal law would be the common law version. Model penal code would be the advanced kind of version that many states have adopted. Some states have statutes based on common law still. Some states have statutes based on the model penal code. Some have a mixture of the two. Model penal code by itself has no authority over anything. It doesn't mean anything. It's just a model. And common law is all gone. Basically, it's all gone. All the states have statutes now. So the statutes control. And they don't typically teach you the specific state statutes in criminal law in law school. Blah, blah, blah. Justice Liberty says, you said, when you said statute. Do you realize statutory law was created as an end run around the Constitution? No, it was not. Different states had statutes prior to the creation of the Constitution. And you may remember Article 1 of the Constitution is where they create the legislature, the legislative branch, specifically to make statutes. And it actually goes into detail about the steps required to make statutes. So that's retarded. And then he goes on to say the opinions of the Supreme Court supersedes all statutes in state cases. Yes, it does, but it depends on what that Supreme Court's deciding on. So in terms of federal law on Indian reservations, until the codes, the 25 CFR, was implemented, then yes, that Supreme Court decision was the law of the land for federal Indian reservations. But as soon as Congress passed the statute, then that nullified the decision, which was based on common law. Or once Congress authorized the Bureau of Indian Affairs to make the regulations, then that superseded the case. So yeah, the case is gone. I'm sorry, dude. He says he bet it wouldn't be upheld by SCOTUS again based on nothing. Active Pooter points out that it is an internet meme. Bill Brennan says, I gave no advice, just stating it's a ridiculous law. Remember, he said that if it's done unlawfully and it's intentional, you can defend yourself. That is legal advice. So you're lying, or you're got a short memory span or something. He again says, I guarantee it wouldn't be upheld if it ever reached the SCOTUS. Again, you don't know that. You'd have to know how it got to the SCOTUS, what they were ruling on. And then he says, it depends on why you assaulted the police. No, you can't assault the police. You can't assault the police. You just can't assault the police. You can defend yourself in some instances, but you can't resist arrest. I don't know why this is so hard to understand. James then says, in no uncertain terms that he's a keyboard warrior and he's rough and tough and amazing. So all hail the mighty, potent masculinity of James Barnes. Obviously, he's not thinking with his brain. So, yeah. Unlawful detainment is an unlawful arrest. If I place handcuffs on you, I'm placing you under arrest. That's not true. You can be detained in cuffs. Arrest is different. You'll know when you're under arrest, typically. They'll take you down to the police station and book you. Then Bill Brennan says, I'm versed in Maryland law, he says. I'm versed in Maryland law, where an unlawful arrest may be resisted. Well, this is AVO. This is like a legal advice, criminal defense advice. You can ask lawyers questions. Ask a lawyer, it's free. Somebody says, can I resist unlawful arrest in Maryland? Just wondering. Let's see, first attorney says, you cannot resist arrest even if the arrest is unlawful. This will lead to charges, time to raise those issues at court. Now, the problem is, while most states have abrogated this law, technically Maryland still has a law. Technically, that's an important word. Technically, Maryland still has a law that you can resist an unlawful arrest. However, there are so many cases that limit the law where it is almost impossible to utilize as a defense. So that's going to be pretty much standard. It's never a good idea to resist arrest. He would think any reasonable person would in good faith feel justified in resisting a blatantly unlawful arrest. Most people who are arrested do feel they're justified in it. But remember, they're looking at it from a different point of view as a juror, and a juror may not agree that you get to resist a blatantly unlawful arrest. Because, you don't know if it's blatantly unlawful until a judge says it's blatantly unlawful. And throwing out terms like blatantly, I mean, how are you defining blatantly? It's like the case that we're just looking at where the guy arrested Padilla because of an outstanding warrant that turns out not to exist. Is that a blatantly unlawful arrest? Well, the officer doesn't know that there's no warrant. Padilla might, but every person that gets arrested for a warrant is going to say, what? I don't have no warrant. I don't know about any warrant. There's no warrant. Everyone is going to say that. So I don't know what the hell you're talking about, Bill. I really don't. You shouldn't give legal advice, though. And saying what reasonable people would think, that's a margin call. I don't think reasonable people in jury boxes, the people who serve on juries, I don't think they would think that you're justified in resisting arrest, especially when the Texas Penal Code says that it's no defense that resisting an unlawful arrest. And then he says the police wouldn't want me on that jury. Probably not. The prosecutor would probably screen you for it and figure out whether you were a fit for that jury or not. That's what the whole voir dire process is all about. But anyway, I hope you enjoyed this. What we have learned is that in Texas, you can't resist arrest, even if it's unlawful. Don't do it. Technically, I'm throwing this out there because I like to be thorough. Technically, you can resist arrest if the use of force to resist arrest or search is justified, if before the actor offers any resistance, the peace officer uses or attempts to use greater force than necessary to make the arrest. But I don't recommend it. If you are not resisting at all in the slightest and the peace officer attempts to use greater force than necessary, then theoretically that right is out there. But you have to remember that you may beat the crime, but you won't beat the ride, and you never know what a jury is going to determine. So I don't recommend it. Anyway, have a great day and happy auditing.